Good morning. Happy Monday. Welcome to the Courtroom Files Live. We will start our week in Florida. This is Judge Wade Mercer doing first appearances.
Okay. He claims that he does not speak Quiche, he speaks Kekchi. It's a different language.
What did you just talk? Did you just talk to him in Quiche or Kekchi or Spanish? What did you just talk to him in? What language?
In Quiche, so I did understand he said Kekchi.
Okay.
Not
My
Quiche.
understanding is that he may even speak Spanish. Can you ask him if he speaks Spanish also?
Buenos días, ¿habla español?
Sí, un poquito, entiendo un poquito de español. Sí,
Very
entiendo.
little in Spanish.
So here's the question. Is he comfortable going forward with the language that you speak? Or is he wanting to stay in jail another day until we can get a different interpreter for a third language? Because I've been told Spanish and Quiche and Quechua, so I have no idea. But I got to have an interpreter if he wants one. Does he want an interpreter?
So I'm not a Spanish interpreter and I'm a Quiche interpreter and he does not speak Quiche. He speaks a different language. So do you want me to ask him in Spanish whether he wants a Spanish interpreter?
He understood in Quiche your initial statement, your introduction, didn't he?
No.
He didn't understand. Okay. So tell me the language that you speak. How do you spell that, please?
It's Quiche, Quiche, and he speaks Kekchi. It's K apostrophe A QCHE. I'm sorry.
K apostrophe A Q K apostrophe A Q C H E.
No. It's K apostrophe E Q C H I.
Okay, that's a different spelling. So make sure I got it right. K apostrophe E Q C H I.
Yes.
Okay, so please ask him in Spanish then, because he speaks a little Spanish. Is he requesting an interpreter that speaks Quechua, or is he comfortable going ahead in Spanish?
¿Usted desea un intérprete en español o desea esperar un intérprete de Quechua para mañana?
No, se puede ahorita en español. Entiendo español también.
If possible, I understand Spanish as well. We can do it now.
Okay. You're here because you've been charged with driving with no valid driver's license.
Your Honor, this is the
Yes,
interpreter. I'm not a Spanish interpreter.
You can't speak Spanish well enough to do that. Okay. All right. Thank you, ma'am. Appreciate your time. Have a good day.
Thank you.
Can you see if what's his name?
Can you see if Mr. Ricardo is available this morning, please? Señor Yat, tendremos un intérprete aquí en un momento. ¿Entiende? ¿Entiende?
Sí.
So what we'll do is when we get to, we'll try to see if Mr. Ricardo is available to try Spanish and then go from there. Corporal, did they even try Spanish this weekend? Do you know?
I do not know. They just said no bond. They didn't give me any information whether or not they had tried Spanish or not.
What I was told is that the jail sheet that came up said they needed an interpreter in Guatemalan. Well, Guatemalan's not a language, it's a country. So I think there was an issue there. It's like someone speaking Mexican. It's not a language, it's a country. So that may have been contributed to the issue there. I don't know that if I was at the jail working, I don't know that I could have done any better.
I don't know. I mean, there's a bunch of different dialects or languages in all around that area. And
so this is a mountainous area of Guatemala is what Amber told me this morning, but she thought it was Quiche.
Two names are that closely sound each other, you know.
So maybe he understands enough Spanish. We just got to get a Spanish interpreter because I can't do it. So we'll come back to him then. The next case on the list is Tori Owens.
So while he brings up the next contestant, good morning again, everybody. Welcome to the Courtroom Files Live. So I caught the beginning of this yesterday while I was doing other work here in the studio. This was in front of a different first appearance judge, and they were struggling to get an interpreter for this guy and figure out exactly what language he spoke. And apparently it's still a struggle for them today. So it's an ongoing thing on day 2 now. Anyways, back to court.
$1,000 on possession of methamphetamine. Do not try to post that, Ms. Owens, because you have no bond in the other case, the violation of state probation case. See if I can find that file. Got them out of order somehow. Yes, there's a no bond warrant signed in violation of state probation, ma'am. So what I'm gonna do is go ahead and get you arraigned on that charge and get you an attorney appointed in that case if you want. I can go ahead and arraign you since there's a affidavit filed by your probation officer and a warrant signed by a judge. Would you like to have an attorney appointed to represent you in the VOP?
Yes, sir.
Listen to Mr. McDaniel, I'm appointing that officer to represent you.
Your Honor, we enter plea of not guilty. Asked to set it on the July 10th pretrial docket, and I advised Ms. Owens that Mr. Green would come by and visit her prior to that hearing. That's no, Sean.
Thank you. Mr. Mitchell, anything?
Is she already subject to random UAs and her probation?
Yes.
I have no idea what she's on probation for.
I was just gonna say,
Yeah, I
if
was.
anything, I was gonna request random UAs in the new charge, but
The violation is based on positive drug tests, so
Okay.
she must be. So, Ms. Owens, I'm going to set your bond at $10,000 again on the new charge. There's a condition of random urinalysis on the new charge if you're ever on bond for that case. But keep in mind, you have no bond in the VOP. Mr. Green will come by and see you. That's the public defender that does, assistant public defender that does VOP cases. He will see you before your court date. Do you have any questions, ma'am?
No, sir.
Have a good day, ma'am. Thank you. Keith Mendenhall. Mr. Mendenhall, good morning. You have a warrant out of Bay County. Mr. Mendenhall, it appears to be a child support warrant. From what I can tell, it's a writ of attachment. It has a purge amount on it of $1,800. What that means is if you post that purge, you're going to be released and you'll show up at court down there on a later date. If you're not able to post the purge, you'll be transported to Bay County and you'll go before either a judge or a child support hearing officer down there. And that person will address your purge and may or may not lower it. But right now, you can get out by paying the $1,800. If you can't pay it, then you'll see somebody down there as soon as you get there. Any questions, sir?
No, sir.
Have a good day, sir. Robert Hastings. You have Robin Gable's number. Just a second, Mr. Hastings.
Yes, sir.
Yeah, well,
but
I don't know if he speaks Spanish well. He'd probably be better off to have that other language because he didn't, his Spanish was broken. I could tell when I talked to him, it wasn't. It was kind of.
Mr. Hastings, good morning. Mr. Hastings, you're being brought back to see the status of your Calhoun County case. I looked at the file this morning and there is a warrant signed by Judge Young down there. There's a no bond warrant. So what that means is you've got the charge here that you've got a bond on, Mr. Hastings, and you've got a no bond warrant out of Calhoun County for violation of conditional release. So Mr. Hastings, if you post bond here, you'll deal with Calhoun County first. If you're not able to post the bond here, you'll deal with our case first and then go to Calhoun County. Mr. Hastings, do you have any questions?
I have arraignment on the 5th in Calhoun County. I don't know. Is that going to be, is there any way to get the
That
global
doesn't-
sleep?
You're not going to be there unless you post bond here, or the other possibility is the judge in Calhoun County does a transport order to have you brought down there. That'd be very, very unusual. I see it a couple times a year in unique situations. But in all likelihood, you're going to deal with this charge first unless you post a bond here.
Yes, sir.
Any other questions, sir?
No, sir.
All right, sir. I wish you the best. Do y'all have his warrant, Corporal?
We have their order of revocation for the conditional release.
What was sent to me was the affidavit, not the actual warrant. So I want to make sure y'all have the warrant. The affidavit's just the one where he's accused of it, but there's a separate document where the judge signed a warrant. So I want to make sure y'all have that.
Yes, we have the affidavit signed by the judge. That's what we
Yeah,
have.
there's a warrant issued, so I'm not sure. Was that something that,
We
it was not a
located
new
it.
arrest? So whoever pulled that off of CCIS pulled the wrong documents, what I'm saying. Because I had to double check. There is a warrant. Mr. Hastings, wish you the best, sir. Let me see. Trent Smith, Brandon Tucker, Glenn Williams. All right, which one of you is Trent Smith? All right, and which one of you is Brandon Tucker? All right, and then we got Glenn Williams coming up still.
Same time. He's waiting on you. He's all right.
All right, Ms. Tucker, take a step to your right so I can fit all three of you in the screen. And Mr. Williams, take a step to your right, please. To your right. Closer to them, Mr. Williams. There you go. So that way I've got you all on screen at the same time. I'm seeing you at the same time because your cases are identical for first appearance purposes. Each of you are accused of violating the terms of your probation or of your conditional of your community control. And in each case, you've got no bond. So what I'm going to do is I want to arraign you this morning because I want to get you a lawyer appointed if you're asking for one. Mr. Smith, would you like to have an attorney appointed to represent you in this VOP?
If I do that now, will I be able to get my own at a later time?
You have the right to hire an attorney at any time with a, you've got to realize if you hire one the day before a hearing is set, then that may create problems. It may cause you to stay in jail and the hearing to be continued, or the judge may say, I'm not continuing the case, in which case the new attorney can say, I'm not representing him then. So yes, you've got the right to hire an attorney as long as it's within a reasonable time before a hearing takes place.
I understand, sir. I would like the public attorney for now.
Okay, Mr. Tucker, same question. You want an attorney appointed,
sir.
Mr. Tucker? And
Yes,
Mr.
sir.
Williams, you want an attorney appointed to represent you?
I really don't know what to do at this point in time, Your Honor. I'd have been in first
Okay.
appearance 4 times.
Well, you're accused of violating terms of your probation. I think this is the first time you've been to first appearance on this case, on this VOP, but let's check and make sure.
He's got a pretrial June 5th. We may have already done him.
I think what happened is I think they amended the VOP to add the new charges on there.
Yeah, that's probably, this warrant is just dated last week. This warrant's dated the 23rd. So you may have been first appearance on a violation of probation, and you may have already got an attorney appointed to represent you, but it was not the current allegations against you. There's been a new allegation made against you is what it appears to me. So do you want an attorney appointed, you want the public defender's office to represent you, Mr. Williams?
There are.
More likely, yes. What is the new allegation appointed against me?
Did you get will you have a new arrest, Mr. Williams?
Like, sir, Your Honor, with all due respect to your courtroom, like, I came before you last week and I was trying to explain something and it was just like a misunderstanding. Like, I'm really confused about like what is going on. Like, I don't feel really like I'm being treated fair. I don't know, like, what are my charges?
To try to answer the question, you have new charges that you've been first appeared on for resisting an officer without violence, possession of firearm by a convicted felon, and possession of controlled substance. So those are the new allegations that you've already been first appeared on. So that's what's led to the amended violation. You had a violation pending before that, it appears, but the new ones, the officer had to allege the new ones. So do you want an attorney to represent you? I'm just trying to get you an attorney appointed if you want one. You want an attorney appointed to represent you?
I mean, I was just trying to see our charge. It said something about some fentanyl. I know nothing about no fentanyl. I don't know nothing about any fentanyl inside the ice at all,
Do
period.
you want an attorney appointed to
Yes,
represent you? That's what I'm trying to do. I'm going to appoint the public defender's office to represent all three of you. Listen to Mr. McDaniel, and then we'll see if you have any questions.
Your Honor, we're going to enter a plea of not guilty. As to set this on July 10th pretrial docket. Guy agreeing to come by and visit them. Mr. Williams is already on the June 5th docket, and Mr. Green may have already saw him, but he's on the June 5th docket.
So Mr. Williams on June 5th, because he's already been arraigned on a prior VOP, and the other two will be in July. Is that right?
Correct.
Mr. Mitchell, anything?
No, Your Honor.
All right. Mr. Smith, do you have any questions, sir?
No, sir.
I wish you the best, sir. Mr. Tucker, any questions?
Yes, Your Honor.
Okay.
Is there any way that I can move up to the 5th? Because I have proof that my PO lied in the report.
Well, Judge Garcia has VOP court once a month, and the date you fall on depends upon the date of your arraignment. That's why I'm arraigning you, is to get you on that earlier docket. So, Mr. Tucker, I don't control her docket. The cutoffs are set by the clerk's office with Judge Garcia's agreement. So based upon the day you're arraigned, then no, you're not going to be moved up unless something unusual happens. The allegation is that you didn't go to NA meetings as ordered. It says that you've only attended one meeting since the judge ordered them on April 21st. The second allegation is that you're behind on your court costs and fines. So that's what you're accused of. So Mr. Tucker, I'm going to ask Mr. McDaniel. I'm going to ask Mr. McDaniel to email Mr. Green. That's the attorney that does public defender cases for VOPs. That is, I'm going to ask him to email Mr. Green and make him aware that you're there with no bond. But I'm arraigning you on somebody else's docket. Any other questions?
Yeah, that's what I'm trying to do, is because I have the form that the chairperson has to sign when I go to the meetings. And that's proof that I've gone to 3 meetings out of 4 weeks. And I've only missed 1 meeting because my car broke down, or my mom's car broke down. And haven't been paying my court costs because she wouldn't let me get a job. My PO wouldn't let me get a job. Every time I told her that I applied or I had been offered a job, she told me I couldn't work until my time was verified or stuff like that. She wouldn't let me go to job interviews or anything.
Yeah, the allegation is that you failed to attend weekly support group meetings with a focus on NA. According to this, the judge ordered you to attend weekly and you're accused of not attending weekly. It's not my case. I'm asking Mr. McDaniel to notify the public defender's office that does these kind of cases, Mr. Green, of your concerns and of your position, but you're not going anywhere. Right now, you have no bond. I'm not in control of which docket you're put on. That's another judge's call. Right now, you're going to be on that July date unless something changes between now and then, but your attorney should come see you in the near future. Any other questions?
No, sir.
Have a good day, sir. Mr. Williams, have any questions?
No, sir, he's good.
All right, let's switch it up a little bit. We'll go to Texas. Say good morning to Judge West.
You've made bond in your case. If you had an opportunity to try to hire a lawyer.
No, ma'am.
So what I'm going to do, Ms. Kirks, is reset your case for about 30 days to give you some time to try to get someone hired.
Okay.
If you get someone hired before the next court date, just bring the reset notice that you get here today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, if you step in front of the clerk right here, she'll give you your reset notice. Jamarian Martin. Good morning. Are you Jamarian Martin? And Mr. Martin, this is your initial appearance in cause number 25 DCCR 0196. You're charged with the state jail felony offense of burglary of a building, and that's from October 3rd of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I can't hear you. Right, so when you were in custody, we gave you a court-appointed attorney, but now that you've made bond, I expect you to at least try to hire your own. So I'm going to reset your case for about 30 days to give you some time to do that. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. Charles Guidry. Good morning, sir. Are you Charles Guidry?
Yes, ma'am.
And Mr. Guidry, this is your initial appearance. And cause number 2341646. You are charged, hold on a second, look at this, with a state jail felony offense of theft and aggregation amounts from January 1st of 2022 through June 30th of 2022. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? You're working on it? Okay, so I'll give you about 30-day reset to give you some time to get that taken care of. If you do get someone hired, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Stephen Wilburn. Good morning, sir. You're Stephen Wilburn.
Yes, ma'am.
Did you get somebody hired?
I've been talking to Mr. Hall at the Hall Law Firm. Just trying to raise the $3,000 for the down payment. I got $800 so far. I think a couple of weeks I'll have the rest of it to get to them.
All right, because it looks like you've been coming since January.
Yes.
This is your 3rd
Yes.
time. All right, you need to try to get him or someone else hired before that next court date.
Yes, ma'am.
All right, your case is getting old. We need to get something moving on it.
Yes, ma'am.
Step in front of the clerk. Hall, Willard Hall. Mr. Macon on Gracie Cassidy.
That's gonna be a plea, Your Honor.
I'm ready for it. Good morning, ma'am. Are you Gracie Cassidy? And Mr. Macon, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Cassidy, in cause number 24 DCCR 1480, you're charged with unlawfully carrying a weapon on prohibited place, and that's from March 28th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 4-year deferred adjudicated probation. You would have a $500 fine and be required to follow all of the rules and conditions of probation. Is that your understanding? Do you, and it looks like the state, as part of that, is going to dismiss cause number 24 CCCR 1480, correct?
That's in the misdemeanor court. I'm not discussing it with the attorney.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Ms. Cassidy is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done. That'll give me more information about you, your case, and then we'll come back for sentencing at a later date. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there. Okay? Yeah, good. If you'll just talk to her, she'll tell you everything you need to do.
Let me interrupt 1 second. Part of this is a forfeited weapon.
Oh,
It's not hers, but it involves another person. I still make sure it's not getting out.
If you want to make sure,
We'll get that
file a motion
motion.
that has the specific information about it, and we'll sign it at sentencing.
Yes.
Okay, just stop and talk to the lady right there at that desk.
James, do you have discovery? I need the discovery.
See, Mr. Macon, you also have Thomas Fisher. Thomas Fisher?
I haven't seen him yet this morning. Might have a few moments to make a few phone calls.
Yeah, let's see if she comes.
One out of two. Oh, yeah, good, great.
Do you need me to?
Yes, Thomas.
Good morning, sir. You're Thomas Fisher? And Mr. Fisher is charged with aggravated assault with a deadly weapon in one case and criminal mischief in the two other cases. And Mr. Macon, what is the announcement?
Your Honor, we've got the discovery and received an offer. I just need 30 days to get Mr. Fisher in to talk to me about it.
All right. Any issues, Mr.
None that I'm aware
Nichols?
of, Your Honor.
All right, so I'm going to reset your case about 30 days. Make sure you make an appointment to go visit with Mr. Macon before that next court date so that when you come back, you'll have an announcement on what we're going to do with your cases. All right, you're free to go. Thank you.
Let's go to Kansas and see what's going on with Judge Webster this morning.
Themselves on out of their device. Thank you. We are on the record in 2024 TR 2854, State of Kansas versus Gabriel James Reese. Please announce appearances.
Jared Regier on behalf of the state.
John Stang on behalf, Mr. Reese is also present.
How does he wish to proceed today, Mr. Stang?
Your Honor, there's actually two cases. You're looking at the TR 2854. We also have a 24 CR 331 that is
I do see that, and we'll be on the record in that one as well. That is a criminal case.
Thank you, Your Honor. In dealing or speaking with Mr. Sweeney, we have agreed to enter a plea of guilty to, I believe it's count 1, possession of marijuana in the criminal 331 case. They're going to recommend a $120 underlying sentence, 6 months probation with court services, with the specific requirement that he obtain a drug and alcohol evaluation and pay the KBI lab fee, which should be $400. There's no fine being requested. In return for that, the remaining charges in the criminal case will be dismissed along with all the charges in the 24 TR 2854 case.
Very well. Mr. Regier, you're appearing for Mr. Sweeney today.
I am, Your Honor, and that is the state's understanding. Additionally, I'm not sure if this was discussed during the context of plea negotiations, but insofar as 24 CR 331 is concerned, it would appear there is also the issue of court costs and the standard reporting probation fee for these types of cases.
And that would
I stand corrected, Your Honor. Yeah, that would have been assumed. Court costs and probation would be included.
158 court costs, $60 supervision. Very well. Mr. Reese, is that your understanding of the plea agreement?
Yes, ma'am.
How do you plead then to, in 24 CR 331, count 1, possession of marijuana?
Be guilty, Your Honor.
Is that right, Mr. Reese? You plead guilty or admit that you did possess marijuana?
Yes, ma'am.
And you did that in Butler County?
Yes.
And was it on February 29th of 2024?
Yes.
And was this in an automobile, a home? Where did you possess this marijuana?
In an automobile.
And where did you have it in your automobile?
I don't know. They just found a little bit. I don't even know where they found it.
I don't
Where did you,
remember off the top of my head, Your Honor, but it was found in his vehicle.
all right. And you knew it was in the vehicle? Are
Yes,
you
he did.
admitting that as part of your plea? Okay. Is that right, Mr. Reese?
Yes.
Okay. I will find, is anyone making you enter this plea today by threats or promises other than the plea agreement?
No.
And you understand you're giving up your right to trial by entering this plea?
Yes.
Very well, I will accept your plea and find you guilty of count one, possession of marijuana in 24 CR 331. Any remaining counts in that case are dismissed. Also, the entirety of 2024 TR 2854 is dismissed. I will follow the plea agreement and sentence you at this time to 120 days in the Butler County Jail. If you do not want to serve that, then you need to successfully complete a 6-month reporting probation. You must call probation immediately after this hearing. Their number is 316-322-41. Standard conditions of probation will apply, as well as special conditions that you obtain and comply and pay for. A drug and alcohol evaluation that is to be scheduled within 14 days. I don't intend for you to start it in 14 days, but you need to at least be on the phone and get an appointment within 14 days. Also, you need to pay $400 to the KBI, $158 court costs, and $60 probation supervision fee. That comes to about somewhere around $618. How much time do you need to pay that?
I can pay it now.
You can pay it today?
Yeah.
Now you'd have to pay it at the courthouse if you're going to pay today. Are you able to go to the Butler County Courthouse?
No, I'm not.
Your Honor, could we have 30 days and I give him a chance to get to the courthouse and get it paid? Would that be acceptable?
That's certainly acceptable. I'll give you 30 days from today to pay. That way we can get the journal entry on file. You can get to the courthouse. 30 days to pay. Call the probation immediately after this hearing. Get your drug and alcohol evaluation started. Of course, you're not to have any alcohol or illegal drugs on this probation, and you're not to hang out at places and with people that have alcohol and illegal drugs available. Mr. Regier, anything further?
Your Honor, the state's understanding is that pursuant to plea negotiations, the state was not seeking a fine in this case. Does the court wish the journal entry to reflect that for purposes of clarification of nothing else?
Yes, that is correct, Mr. Regier. Thank you.
Your Honor.
Okay, if there's nothing further, we're in recess and Mr. Reese is excused to call his probation officer. Mr. Stang, have you anyone else on this docket?
Not today. Thank you, Your Honor.
Thank you. Then you're excused, as is your client.
Thank you.
You're welcome. Is Mr. Patterson back with us yet? Next time he comes back, Jim, would you hold him so we can take up the lady there in the jail, Ms. Stewart? All
Yes.
right. Thank you. Mr. Lovett, who do you have?
I have Miss Banzit, Your Honor. She's present over my shoulder.
We are on the record in 2024 TR 3485, State of Kansas versus Christy May Banzet. Please announce appearances.
Jerry Regier on behalf of the state.
May it please the court, Miss Banzet appears in person of either counsel Matthew Levitt.
And Mr. Lovett, how does she wish to proceed today?
Your Honor, in discussion with Mr. Regier, we've had some email correspondence. It's our intention to enter a plea to amended count 2, which will be the ignition interlock violation. The county attorney's office will amend to the subsection A of the statute, as opposed to the subsection D under which it is currently charged. In exchange for a successful plea, county attorney's office will also be dismissing count 1, which is the speeding violation. In exchange for this plea, the county will be recommending a 12-month controlling sentence, a $400 fine with court costs. They will also be willing to recommend 12 months of non-reporting probation. So any jail time will be stayed, conditioned on obeying all laws, not driving without valid license and insurance, and then finally paying the fine and court costs. We will be making a defense request for approximately 30 to 45 days time to pay, and are willing to proceed with the court's colloquy at the court's convenience, including waiving jury trial, etc.
Very well, thank you. Mr. Regier, that is your position?
In general, Your Honor, the state's understands that the issue of repayment of the case was not discussed during the context of plea negotiation, but the state is prepared to stay silent on that issue. The state is prepared to dismiss count 1 in exchange for a plea to an amended count 2. The ticket does appear to charge count 2 under KSA 8-1017A4. State's understanding is that upon entry of a plea, the state would be amending the same to subsection A1 of the statute.
That's correct, Your Honor. I did misspeak. It's not subsection D. It would be the A1, not the A4. I was off on my letters as opposed to my numbers.
You know, those statutes make that very easy to do, don't they?
They do.
Okay, so Ms. Bansett, is that your understanding of the plea agreement?
Yes.
Is anyone making you enter this plea today by any threats or promises other than the plea agreement we've been talking about?
No, Your Honor.
You understand that if I accept your plea, you'll be found guilty. There will be no trial and you won't be able to appeal your conviction.
Yes.
You understand you're giving up your right to trial, including your right to jury trial then, is that correct?
Yes.
And how do you plead guilty?
Yes.
Okay. By pleading guilty, you're admitting that you did violate KSA 8-1017A1?
Yes.
Just a moment. Can you tell me in your own words what you did that makes you guilty of this violation?
One moment, Judge.
I was operating a vehicle without the interlock device installed in that vehicle.
And by not having it in your vehicle, you did circumvent, she's pleading to the circumvent or inoperate, is that right?
That's correct, Your Honor.
All right, so by not having it, you circumvented the court's order to have one in your car?
Yes.
Okay.
And just for a fully accurate record, it would be circumvention in violation of the Kansas Department of Revenue's order. That would have been subject to the Department of Revenue, not the court.
Yes, thank you for that correction and clarification. I do accept your plea as knowing involuntary with the factual basis. I find you guilty. Per your plea agreement, count 1, speeding is dismissed. Your sentence will be for 12 months. Your fine is $400 plus $158 in court costs. Looks like your total is about $558.
And Your Honor,
Now, yes.
forgive me, but for purposes of accuracy, of course, if the court is, perhaps the court is aware of something I do not know, but it would appear this case is charged as a traffic matter.
So it is $108. Thank you. I'd make it $508. And if you do not want to go to jail between now and the next 12 months, you must successfully complete your 1-year probation. Per your plea agreement, I will not make you see a probation officer. However, you'll still be on probation with the court for 1 year from today. And your conditions primarily would be that you not violate any laws in the next 12 months and that you pay your fines and costs of 508. I will give you 45 days from today to get that paid to the clerk of the district court. If you do not have it paid in that time, you can be in violation of your probation and it could be revoked and you could go to jail for 12 months. Furthermore, you could lose your driver's license for not getting it paid for a period of time. It could be that the cost would be turned over to collection agent. And the collection agent would have all the powers that collection agents have. So probation is straightforward. Don't violate any laws. Don't have any alcohol or, well, I'm going to leave that one. Just don't violate any laws and pay that 508 within 45 days. Anything else, counsel?
Now, from the state's perspective, Your Honor.
Mr. Robert?
Nothing from the defense, Your Honor. Thank you.
You're welcome. Thank you. Ms. Besmet and counsel are excused.
Judge, I had one other matter that originally was on docket for today. I believe that it's been resolved by means of diversion already, which has been on file. I wanted to just inform the court, in case it was still on docket, that we had reflected through Odyssey that it was canceled. That's on 24 CR 448 on a Mr. Iverson.
Well, I'm not seeing him, so apparently we are in agreement that he is off docket. Thank
Very
you.
good. That was just a double check, Judge. That way, if it hadn't made it off docket, that we weren't playing behind the 8 ball. So I appreciate that. That's all that I have, Judge. Thank you.
Thank you. You and your client are excused.
Let's head up to Michigan and say good morning to Judge Middleton.
The first matter we're going to address is People versus Miranda Jean Lundgren. The file number is 25671FY. Ms. Lundgren was charged with resisting obstructing a police officer. The matter was reduced to attempting to resist or obstruct a police officer. I asked to set the matter out for a bit. I got the police report. Ms. Davis, I'd like to thank your staff. They also got me the videos, and I'm technically not very capable, but I got them and I got them opened and I watched them and they were very informative. So thank you for that. All right, having said all that, this is the time for a sentence on a misdemeanor charge of attempting to resist or obstruct a police officer. Ms. Hines, what would you like me to know?
Your Honor, if you watch the body cam, you're aware that the reason that the police even came to the McDonald's that day was because they said she was smoking methamphetamine, which they found nothing in the car. She had her dog, she was eating a breakfast sandwich sitting in McDonald's, and then the police came up, and it was then just a bunch of unfortunate situation. I just had one very similar next door with Judge Pattison, where basically the prosecutor said, and the judge agreed, but for the stubbornness of, my client, they got an R&O. So I think here it was the same. She was able to get her gun back and the ammunition, which I'm appreciative for the officer releasing that to her. I think this shouldn't be a probation case. It should not be a jail case. It should just be fines and costs, and hopefully she can move on and not have to deal with the situation like this again. Thank you.
Ms. Davis, you probably saw the same video we saw. What's your take of this?
Your Honor, I did not watch the video as far as the timing that we have to do things. This was one that Chief Assistant Prosecuting Attorney Robert had handled. So, the notes that he left are that this started as a simple, expired plate, but for the behaviors, we wouldn't be here today. So, I'd leave it to the court's discretion as to what punishment to impose for this. Thank you.
All right, thank you. new statute, the criminal justice reform legislation, presumed there's no jail and no probation. I don't know that I need a probation, but Ms. Lundgren, what would you like to tell me?
Just that the incident was off of a false police report, and my tags were there in the report, in the police report. It says that he wanted to separate me from my pistol, which was in the back. I had just done my first CPL class the day before, but that's not what it was, because what he stated on the video was that he wanted me out of the vehicle, so I didn't turn my car on and run him over, because he said, I need to take off your plate. I said, you can take it, because I turned my car off. I wasn't going anywhere or resisting, trying to resist. He come back and said he wanted to search my car. I said, I don't give you permission to search my car. And then he says, well, I want you out of the vehicle because I don't want you to turn the car on and back up and run me over. I said, sir, I'm not going to do that. He's like, I want you out of the car. I said, I don't want to get out of the car. And that's when he proceeded to open up my car door and stick his arm on my throat. And here I am.
All right, you have zero remorse for this. I don't have any sympathy for you. You stubborned your way into an arrest. He said more than once, man, I really don't want to do this. He's a police officer. He didn't just decide to come check you out. Somebody made a complaint that you were in there. I don't know whether it was valid or not. Somebody called Central Dispatch.
It's not valid. There's
I don't know that. So he
so
comes there, and because he's sent there by Central Dispatch, you got a dog in the car. Were you living in the car?
No, sorry.
It had so much stuff in it. I didn't know if maybe you were living in it temporarily or something.
What does that have to do with?
I don't know. So anyway, the police get sent there because somebody calls in a complaint.
That's right.
All right. So he comes there. You're not terribly disrespectful. You didn't want to do what he wanted you to do, but when your plate was invalid,
with it.
And up to the point where he asked you to get out of the car. And he has a right to ask you to get out of the car. The car's got an improper plate. He doesn't want to leave you in the car with the keys while he's behind your car.
That's what he
and
stated.
That is what he said. You said that's ridiculous. And maybe not.
Oh, I said, I'm not going to do
All
that,
right,
sir.
This is my turn to talk. Stop interrupting me, and I'll give you a chance to say what you want to say. You said, I'm not going to do that. And he's like, lady, are you really going to do this? It was a huge pain for him and a huge pain for you, certainly. And then they had to deal with your dog and your car. It could have been so much easier. You could have just stepped out of the car. He would have taken your plate. And he would have got a ticket, which was a civil infraction, and that would have been it. And you're not even sorry now. You could have just made this so much easier. Yes, he had a right to ask you to step out of the car. The car had an unlawful plate. He was going to take it. No officer is going to get behind somebody's car while they're in it with the keys in it. He didn't ask you for the keys, but I don't think he would have given them to him. I
would have, yes, I would have.
I don't know why somebody called. I didn't get the Central Dispatch tape, but they didn't find anything. So you're right. There wasn't anything to that.
Right.
And Your Honor, I guess just to clarify too, admitting that you have the pistol in there, absolutely bring that up to the officer. But the officer isn't just going to blindly trust that it is where you say it is in the vehicle too. So for safety issues, that is where I'm looking at, the officer.
I can understand that point of view. This is when he came up to my vehicle and asked for my license. I gave it to him. And I said, I'm also going to tell you, I have a pistol in the car, and I just did my first CPL class. It's in the back, it's locked.
But again, that's an expectation that everybody that they talk to is going to tell them the truth, and they can't make that judgment alongside. So I don't want you to feel like this officer was
I mean, I
Keeping
can
on you.
understand that point of view. That didn't run through my head when he was asking to take my plate. He
Well,
didn't say that to me. He didn't say, I want to remove you from pistol or anything like that. He just said he was afraid that I was gonna back up, turn the car and back up and run him over. And I said, I'm not gonna do that,
all
so.
right, well, so he trusts you, you're not gonna do it. Who knows the next person? And he knows you've got a gun in the car. He wants to get you out of the car.
I could, like I said. I
And
can
you
understand.
dumbassed your way out of it because you wouldn't get out of the car.
I didn't
And you're like, I'm
think
not,
that it was necessary, but I mean,
it was necessary. So how would about 90 days in jail be necessary? I see zero remorse or repentance for you. If I were to give you a drug test today, what would it show?
nothing.
All right. So you're not struggling with anything?
No, where's this?
No, not at all.
Those, I can't make her be,
I mean, I'm following the
can't-
law like I just.
you weren't following the
How
law.
can I be a citizen that I have no priors here in Michigan. I've lived here for 7 years. I don't do drugs. For one, like I don't understand where that's coming from. It is a huge issue for me. I've already had to pay to get my car out, all that stuff. Like, I mean, I don't understand how you're saying that it's like
Well, I can't
no
make you understand.
consequence to me.
We're talking two different languages. You're concerned about your rights and privileges, which you have. But at some point, the rights of the police officer supersede yours.
Which it did, yes.
He knows you got a gun in there. He's gonna get behind your car. There's a dog in there. And he's by himself. He doesn't know what's what. Someone called and says you're using drugs at that location. He hasn't done any investigation yet. He doesn't want to leave you in the car with the keys and a gun while he doesn't know you from Adam's cat. Every day, police officers are shot in this country by people who, for whatever reason, don't want to cooperate with the police. He's following his training, and I thought he was quite respectful to you. You didn't do what he wanted to do.
Also, this is my first time owning a pistol, so I guess that didn't register when he pulled me over. I've never had trouble before, so when I said that I didn't want to get out of my car, it had nothing to do with that. But he stated that there was nothing going on when he first pulled up. So, I mean, I guess I'm not familiar with everything, so I don't, it was just a whirlwind.
I can't make you be repentant, so I'm not gonna do that. Are you employed somewhere?
Not at the moment.
What kind of work have you done?
Factory work.
Really, the sum total of your resisting was refusing to get out of the car. Once you got out of the car, you were not any more disrespectful than you were before. You cooperated, you were concerned about your dog, but this was your own fault. I believe you spent 2 days in jail. You got arrested on the 14th. That's not right.
Looks like she went in on the 13th PM. Was
Bond was
released on
posted on the
14th.
7th. Were you you weren't in jail that long? How long were you in custody?
I would say about 2 days.
The release date was 4/14 at 16:07.
And then at some point, they must actually serve the warrant, and then she had to post again on May 7th. I think she spent a total of 3 days. We'll call it 3 days. Credit 3 days. As I indicated, I don't know any reason to put her on probation. There's a presumption of no jail. As she indicated, I don't know what she has in other states. She doesn't have much of anything in Michigan or in our system.
A couple of OWIs.
Yes, and what state was that in? Indiana? All right, there's a $125 fine, a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. That's $400. She did post a $1,000 10% bond, so the court keeps 10% of the 10%, which is $10, and $90 can be applied to the fine and cost. So it shows $310. Can you pay that by the end of July? Or would you rather have a payment plan?
Whether you extend that a little bit more. Some issues going on right now.
All right, I'll make this due by August 15th. Oops.
Yeah. Yeah, there's a cost.
So this court has online.
Yeah, you can.
The word of advice for you and anybody else is the officer asks you to step out of the car, step out of the car. All right, Ms. Lundgren, you're free to go. I don't know that there is a good answer to that question. All right. All right. Morning, Mr. George.
Morning, Robert. Morning, Steve.
Today.
Real quick, James, you're wondering about probable cause. I assume you refer to her being removed from the vehicle. It's been a decade and a half, more than that now, since I've lived in Michigan. But I do know their concealed carry requirements are a little more strict there. And I believe if you disclose you have a weapon and you're in a vehicle, the police officer does have a right to remove you. So there's that. Let's get back to Judge.
In December of 2022, you assaulted your boyfriend, living together, dating relationship, James Cooley, as a second or subsequent offense. That was a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. It was authorized by former Assistant Prosecuting Attorney Casey Johnson. Then you were given an appearance date and we didn't see you for 2.5 years. And you got picked up and arraigned on the bench warrant. The matter was set for sentencing today. You gave an update and although you were charged with assaulting Mr. Cooley, you certainly told us what your current status was, that you went to get away from him and he followed you there. Anyway, I recall the bench warrant, reset this with Ms. Hines, and gave the prosecutor a chance to give any input. Ms. Hines, what would you like me to know?
Yeah, Kira's back in Michigan, as the court's where she's living with her mother. It's my understanding that she still wants no contact with Mr. Cooley. I think she's, I watched the video of her arraignment back with you, and it sounds like she's still fearful of him. But I'm glad she's been in contact with me when she came back, said she was coming back. So she's done the right thing, that's for sure. And if the court remembers, when we had the pre-trial and she entered a plea, it was a plea to DV first with probation request. That's what happened back in January of 23. Hopefully things are better mentally for you, taking medicines, maybe getting some mental health treatment. I was the attorney for Kiara when you were in the juvenile court. Do you remember that? So I know she struggled, Your Honor, and I know her parents have always been committed to her and wanting what's best for her. So I'm glad that she's back home living with them and hopefully getting some mental health treatment that I think is important for her. Thank you, Your Honor.
Ms. Davis, you didn't have the benefit of being here at the time of her plea. She presented as a victim of assault and from this defendant. Now, 3 years later, and she came back here to take care of this. I don't know if we got any victim input from him at the front end or anything now. Have we heard anything from the complainant?
We've not heard anything lately. When this occurred, at some point he did ask to have the no contact lifted back in 2022. I guess I look at this as I'm glad that she turned herself in. It took a couple of years to do so. It looks like from the ROA, she had been in contact with the court, wanted to do things by Zoom. She's out of town, those sorts of things, but never really followed through. I guess what really strikes me is her assaultive history and the number of times that she's been arrested, been in trouble, resisting, obstructing, assault and battery, DV. This instance, I read the police report and she alleges that he shoved her first into a door, but then her striking him with a crutch, swinging at him twice, missing his leg, but hitting him in the head and causing a laceration. The witnesses that were there, uninterested neighbor witnesses, didn't see the shove that she claims, but they did see her striking him with the crutch. So I hope that in the last couple of years she has matured, and didn't have them run another lean to see if she'd had any more arrests anywhere, if she's been in Ohio.
I didn't think to do that either. I asked her that and she said no, but I didn't think to run a new lean.
We both went to jail in Ohio when
Oh, you told me the charge got
he broke in my
dismissed.
house and attacked me in Ohio. Same situation that he did here.
And you told me those charges were dismissed.
Down to the obstructing justice, because when they were arresting us, we were arguing again, so they only charged me with that and dropped the assault charge. And because of my Ring camera, because he broke in through my door.
He was arrested for assaulting you. An Ohio case was dropped.
Yeah.
I don't think you told me they arrested you too.
No, yeah, we both went to jail that day.
And you ended up being convicted of obstruction of a police officer?
Of a justice, because they were trying to take my phone and his phone for the Ring camera, and he and I were like still kind of arguing, and I smacked the phone out of his hand, and that's what they charged me with.
Well, those are the very things Ms. Davis is concerned about, your temper.
So with that, I mean, I'd leave it to the court's discretion on what.
Well, she has a prior domestic violence. She's not eligible for a deferral. This is several years old. She spent 2 days at the front end and 1 day at this end for 3 days. Are you on probation in Ohio?
No,
That case is done?
yeah.
All right. I saw you in May, a couple weeks ago. What have you got more established since I saw you last time?
I'm planning to get my Medicaid and things switched over to go to Covered Bridge for the mental health aspect, and my mom's letting me stay with her. And I have no contact with him in any way and haven't.
All right. I think I'm gonna do a probation to
he's
make
working
sure
for it.
these things happen. I'm gonna put you on a 12-month probation, which means you could be discharged at the end of 6. I'm gonna order 13 days, credit 3 days, and of the 13 days, 10 are deferred. You're not gonna go to jail if you do what I ask you to do. I think you could benefit from the women's anger management class, but I think you already did it once. But I'm gonna make the fine 0. You don't have much money. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee, $480 probation oversight fee. We're gonna do no drugs and no alcohol, no assaultive behavior. Cooperate with CMH. Sign a release. CMH is synonymous with pivotal. Take meds as prescribed. No contact. James Cooley. You have children together, correct?
No, my son's not his biologically.
All right, I'm gonna do this probation to help you get plugged in here. If you're gonna live here, I wanna make sure you're getting services. I wanna make sure if you need community mental health or pivotal assistance, you're getting it rather than talk about doing it. If you're prescribed medication, I wanna make sure you're taking it. Ms. Davis kind of hit the nail on the head. You've got anger issues, and I'm not saying that you weren't a victim here and haven't been a victim since, but this behavior seems to be continued into Ohio. All right, let me give you a referral downstairs to the probation department. I can always amend the probation if we feel that women's anger management is appropriate. The good news, Ms. Mullins, like I told you the last time, you don't have a warrant hanging over your head. This matter's been resolved. We went through with a sentence. You're on probation. No assault or threatening behavior, no drugs or alcohol, including marijuana. Cooperate with Pivotal. I want you to make an appointment, not talk about making an appointment, and follow their instructions. You take this form downstairs to the probation department, they'll get you started on that probation. Let me add those totals up, they're not good. 125 plus 150 plus 480 is 755. You did post some bonds, but they got forfeited a long time ago for you failing to appear. And I gave you a PR bond and you held up your end of the deal because you came back when you were supposed to. So good luck to you.
Thanks, Your Honor.
Yes.
Let's switch it up a little bit. Let's go to Louisiana. They are doing a pardon hearing. Let's see what's going on with that.
Deputy Warden Ashley Olivo. Taylor Graphic Classification. Carmen Shipley, inmate records. Jody Sturgeon, Program Consultant.
Very young.
All right, thank you. And we have before us Mr. Burgess. Good morning, Mr. Burgess.
Good morning, ma'am.
I have your DOC number, Mr. Burgess, as 105495. Is that
Yes,
correct?
ma'am. Yes, ma'am.
Right. Before we start, I'd like to recognize the folks who have joined us this morning who have an interest in this case. We have on Zoom, we have the Parole Project, Mr. Channing Blake, Susan Birch, both of whom will be speaking on your behalf. She's also on Zoom. Here with us, we have the chaplain, Jay Jackson. He'll be speaking on your behalf. We also have some opposition here today with us in Baton Rouge. We have from the DA's office, Monica Doss. We have the district attorney, Mr. Philip Terrell from Rapides. We also have Mr. Joseph Kimball and Charlotte Hockersmith. Mr. Terrell and Mr. Kimball will be speaking at the appropriate time. First, Mr. Burgess, let me read some information into the record. You are classified as a fourth felony offender. Can you hear me all right?
I can't hear you.
All right. Warden Olivo, if he needs some assistance with hearing us, we need y'all to help us, please.
Yes, ma'am.
So ask him, is he a fourth felony offender?
Yes, ma'am.
Okay, and you were sentenced in March 1982 to a life sentence for first-degree murder.
Yes, ma'am.
Then you have another sentencing date in June 1984 for a simple escape. You received a 2-year sentence consecutive to the life. Is that right?
Yes, ma'am. Yes, ma'am.
Right. Mr. Burgess, I understand you have some, maybe some medical issues, but we'd like for you to tell us why you submitted an application to commute your sentence and why do you think we should grant that request?
Well, I submitted it to show the board that I'm not the person I was then, and before I had this stroke, I went through all these the things that we're supposed to do, and it hurts me to my heart, you know, to know that the pain and suffering that I cause people, that it's.
Slow down and get your thoughts together.
I mean, it hurts. It hurts to what I did to that family and what I did to my family, but mainly to them kids. And I've tried to do everything I could to come to an understanding that that's not the way you live. And through changes in life, and through the courses and stuff that we did up here, and through just being able to, we used to be able to talk to kids up here, and we still do, and to try to make them understand, don't do what we did. Don't follow this course. You know, and man, I'm sorry, I can't get this out.
Okay, that's okay. We're going to come back to you and ask you some specific questions. Maybe that'll help. Let's hear from Warden Oliver. Warden Oliver, what can you tell us about Mr. Burgess?
So Mr. Burgess, AU'd in 1984. He served 43 years. He, like you stated, is a life sentence for first-degree murder and simple escape. He currently resides at Camp F, which is our trustee housing area. He works the janitor cleaner in that area. His last rule violation was in 2000, was a Rule 1. He's had 35 DV reports since time being here. He's completed anger management, 100 hours, thinking for a change, substance abuse, and his Tiger is low. I will tell you that he does have history of strokes, which, as you can see, he functions fine. He just sometimes has trouble getting his words out and stuff.
We appreciate that. All right, so let's hear from the folks who want to speak in support of Mr. Burgess. Could we hear from the Parole Project, Mr. Blake?
Good morning to this honorable board. Channing Blake with Louisiana Parole Project on behalf of Mr. James Burgess. Because of his trustee status, his programming, AANA facilitator, the fact that he's on the CPR team, he's been sober since 1995, and he supports vets incarcerated, and he also does youth mentoring through the church. We've accepted him into our program. Should the board give him a favorable recommendation, we're going to give him transitional housing, employment assistance, mental health and substance abuse evaluations, and also he's going to take social norms. He will also be assigned a reentry specialist to mentor and guide him through the process. Based upon his record and his rehabilitation, we ask that you grant him a favorable recommendation today. Thank you so much.
Thank you, sir. Ms. Susan Birch, we hear from you, ma'am.
Good morning. I've known James for 20 years, a little over 20 years. I met him through my husband who was serving a life sentence at Angola. My husband had some struggles and James was always there to support him in getting back on track. It came to a point where his struggles became too much and James said, look, you get it together first and then I'll help you. I'm not going to help you get it together now. You've had long enough. I need you to get it together first and then I'll help you. I brought my kids to Angola to the rodeos, to visits and things like that. James served as a mentor to my son, who is now 33 years old and doing great. He had some struggles while he was in school, and James talked to him on a regular basis, just telling him, hey, you don't want to go down the wrong road. Just, really being supportive and encouraging to him and letting him know what can happen if you do go down that wrong road. And I think in large part due to the mentoring that he received from James, my son is doing great. He holds down a job. He owns his own home. I live on his property, so he is doing great. James also mentored my daughter who just turned 25 and just got married. She is actually still in contact with James. He calls her his boss lady because she would go to the rodeos and she would price his merchandise and, tell him how to do it and everything. But in the 20 years that I've known James, I know that he had already been there for a period of time. And I know that he wasn't the same person then that he was when he committed this crime. Today, he's not the same person that he was 20 years ago. 20 years ago, he was a little bit more rough around the edges than he is now. He has been my rock. My husband did pass away. He did die of an overdose at Angola. And I struggle with that to this day, but James has been a constant in my life. And he's just been such a great friend to me. And I just think that he deserves a chance. He's not the same person. He is sorry for the things that he did. And those things were horrible. But he does deserve a chance. And I ask with all my heart, and I pray that you see fit to give him an opportunity to prove that he has become a better person. Thank you.
Yeah, thank you. We appreciate hearing from you. Mr. Jackson, could we hear from you, sir?
My name is Gerald J. Jackson. I served as a chaplain in Angola from 1999 to 2016. During that time, in fact, the very first visit I ever made to Angola was in August of 1999, and I was attending a Bible study program. And James Burgess was in that class. And I have to say that ever since then, I have stayed in constant contact with James, and he has been an active, participating member of our church community. And what I'm telling you, he's always been there. So I've gotten to know James quite well, I say after 25 years. And one of the things that really stands out in my mind was the fact that there was a time, not too far back, that his mother was seriously ill and she ended up passing away, that I realized that James was a mama's boy. And you start seeing a person's character a little bit when they start talking about their family and the effect that their mom had on them growing up, and how he has developed and matured as a person. And just like the previous speaker said, James has really advanced and he continued to advance the entire time I've known him. When my wife goes up to the rodeo with me sometimes, we always make sure we visit with James. He's met my family. He's the type of person that you can just see the progress he's made. You can see what kind of effect he's had on the students when they've gone up there for these retreats, because he's a small group leader. He's phenomenally effective because he does talk to them, he levels with them, and he does not want them to be the person he was that got him to Angola. He realizes his mistake, and it's one of the things that I think is vitally important. He realizes what he did was wrong, and it's hurt him. It's given him a catapult to be a different person today than it was back then. So again, I'm here to recommend that y'all give him a favorable vote because I do see a major progress in his life. Okay.
Thank you, sir. All right, now we'll hear from the opposition. And I'll let Mr. Kimball or Mr. Terrell.
Yes,
Mr. Kimball, you want to go ahead and go first? Yes, sir. Thank you.
I'd like to take this opportunity to thank you, allow me to speak. I'll do my best to keep it to a minimum. This is an opportunity that I was never given as a child to speak during his trial. See, even though I was a child of only 10 years old, I was a victim then, as I still am here today. I never was allowed to share some of the things with anyone then that I'm going to share here today. I would like to start with how the actions of Mr. Burgess has affected my life and even those of my family as well. Beginning with the time right before he planned and in fact murdered my father in cold blood. Like when he was standing in my living room with his friend while I was sitting on the couch just 2 or 3 feet away from me. I could hear the excitement in his voice as he stated that he could not wait to know what it felt like to kill somebody. At that time, he was holding a .22 caliber handgun, and all of a sudden, bang! Mr. Burgess had shot his friend in the foot and laughed about it like it was nothing. Mr. Burgess broke into my home, lay in wait for several hours until my father got home so that he and his partner could shoot and kill my father. He had several hours to change his mind, to think about what he was doing, to think how wrong it was, and get out of there and leave. But no, he was too excited for the thrill. kill somebody. He and his partner at that time had time to go through and eat food from my refrigerator and drink beer. Had several hours to go through and plan everything. At this time, the same man who shot my father in the head, when my dad looked up at him, Mr. Burgess walked up to my father, who had just been shot and was trying to get up off the floor and stepped on my daddy's throat, forcing him back down to the floor, while looking him in the eye, and shot him in the face with a .45 caliber longbow, making sure he was dead. Then trashed the very home that I lived in, my family, my sister, and all, to make it look like a burglary gone wrong. I, being 10 years old, as a child, along with my sister, were ripped and stripped of our family, our home, our school, and everything we knew. We were robbed of any chance of a normal childhood whatsoever. After my sisters and I were forced to being bounced between multiple family members and friends, eventually being split apart from each other, we had no one to trust, no one to count on, or even to support us mentally. So I built up a wall of protection around myself, that the only person in the whole entire world that I could trust or even depend on was myself at such a young age. I had a very difficult time dealing with life in school and ended up dropping out of school in the 10th grade after being teased, made fun of, feeling so misunderstood, not having anyone to go to. Almost committed suicide at the end of my life. I had no reason to grow up as a normal person and contribute to society. No reason at all. I had every reason to turn to the streets and become the same thing he was. But I chose different. My children have had grow up without ever knowing their grandfather, and their children without knowing him as well. You see, my daddy would be 83 or 84 years old here in a few months, in about a month or so right now. He had not been, had he not been murdered by Mr. Burgess. Father's Day's coming up. It's been right almost 45 Father's Days that I have spent. Me, my sisters, my family have spent without seeing my father. His family's got to call him, write him, visit him. I visited my father yesterday. You know what I saw when I went to visit my father yesterday? Earth, the ground. I looked down and I saw a piece of concrete square on the ground with a metal plaque on it, his name, date of birth, and date that he was murdered. Not only does Mrs. Burgess's actions on that day affect him, but it affected my entire family and the rest of our life for there in the rest of our lives. I cannot fathom why Mr. Burgess has the right to request to be set free after being sentenced to life in prison without the benefit of probation, parole, suspension of sentence. See, on that day, Mr. Burgess took away all of my father's rights. He set free today, but I can't bring my father back. I respectfully ask that you please reject his request for clemency. I know that the people of the great state will be much safer here if you do. And I can only hope that if he were to be set free, that he will never have the opportunity to take that, what he did to my family, to any of yours or anyone else.
Thank you, Mr. Kimball. We appreciate the fact that you were able to share those words with us this morning. Mr. Terrell.
Good morning, ladies and gentlemen. Thank you so much for the opportunity to be before y'all. Obviously, this case is important to us because we took the time to drive down here to appear before and we were there. And these, Mr. Kimball flew down from South Carolina where he made his new home. They started out, they were literally brooding when they were kids, from this little town. Don't get walked up to each house. It's not town, it's just a little community outside of Pine. And I'm not going to belabor the fact because I know y'all have read this entire thing, y'all know everything about it. But as Mr. Kimball said, they were uprooted from their childhood by this man's action. I want to point out briefly, y'all know the facts, so I won't go into that. Let me point out briefly some of the stuff that stood out to me. If you notice, the offense is particularly heinous, and in my view, the other two people who were involved, their actions were heinous too. You got elements of domestic violence. You have elements of all, just almost every malintent that you can think of. This is the man who got hired, who agreed to take the money to kill the victim. In my mind, that's even worse than the bunch. That's just what happened. He pointed out to you that he, on May 30th, he gave a complete confession to the Refuge Sheriff's Office and stated that he'd been hired by Maul with the promise of $10,000 in Kimball's truck to lay in wait with the revolver and kill him when he came home. My victim said they were there at least 3 hours and they had every opportunity to say, you know, this doesn't make any sense. This is wrong. We shouldn't do this. We shouldn't take this man's life. He didn't do anything to him. Another thing, and in addition to him being a fourth offender, after he's convicted of first-degree murder, he escapes. He and his co-defendant escaped from the Refuge Parish Jail by cutting a hole in the ceiling in the roof. He stayed on the lam for 4 days before they caught him. That's not the action of a person who is not approaching being a sociopath. Point y'all real briefly to the offender's statement and some of the things he said today and what he said in his application, why he sought commutation. He said, I can't deny I was there. He doesn't say I can't deny I shot the man between the eyes and lay in wait for him for 3 hours. He said, I can't deny I was there. He said, the main part of this is understanding what happened. No, I will submit to you, the main part is that he murdered this man in cold blood for the promise of money. Then he goes on to say, I am accountable for my stupid and unreasonable behavior. In my view, that's somebody who's not willing to own up to their responsibility. It's not stupid, irresponsible behavior. It's cold-blooded murder. He says further on down in And, well, the worst part is when it hit home with me. No, the worst part is when that 45 went through my victim's face. My stupidity and childish thinking caused my misfortune in being involved in this crime committed by the Indians. Now, after maturing, I have grown into an older man, and that has led me how to think and act. We was 21, almost 22 years old when the murder was committed. What a child. This is not the act of a child. This doesn't have anything to do with a bad decision. It's cold-blooded, calculated, premeditated, planned out, murder for hire. And then he goes on to say that he's doing mentoring and he's come a long way. And I'm not here to say that he's not. And it's not up to me to say whether or not he's saved. I hope he is. I hope he goes to heaven. But that doesn't have anything to do with the act that he committed. If he's going to mentor people, he needs to I submit to you that he needs to mentor them and then go. Couple of the last points that I'll make to y'all. It's obvious that the anguish to the surviving victims, I mean, that's clear. Y'all can see that. Just imagine that happening and them bearing this all their lives. The action by Mr. Burgess is not the action of an incestuous juvenile gone astray. It's a cold-blooded contract here. Our justice system made a compact with these victims. I would ask this board to honor the agreement made with them. Justice depends on it. Please grant the relief they deserve by denying the relief that was killed action. Thank y'all very much for listening to us.
Yes, sir, thank you. All right, Mr. Burgess.
Yes, ma'am.
Your case was assigned to Mrs. Stapleton. I will turn it over to her. Her questions, please.
Yes, ma'am.
Hey, Mr. Burgess, well, you've heard the statements from the victim and the DA, and I listened to the statements also from the people that are in support for you. A good many of those are what I had written down to say myself, so they've been covered. So, you know, you've had many opportunities to take classes and stuff. You've done that. That was covered by the parole project. During your time earlier on, you had 35 disciplinary reports that I had noticed. But one of the things that, you know, the DA just brought up that I had put there, that you said that, you know, that you were a stupid kid. And I had put, you were 21 years old, you weren't stupid. 18 people are going to war, you know, so
Yes, ma'am.
that was, you were far from a stupid kid. And then the simple escape, I noted that the fact that even though Mr. Nall testified against you, y'all remained friends in prison because 2 years later, y'all did your escape together. So that was an odd turn of events as far as I was concerned also. And then I noticed that the price, that y'all were talking about the price. And in your conversation, and, you know, it ended up being $10,000 in a truck. But you made the statement, or Mr. Nall made the statement, that, well, usually I charge $20,000 for a job like this, but you being a friend and all, I'll do it for 10. So where did I usually charge $20,000 for a job like this? Had you done this before?
No, ma'am.
But you're just trying to get more for your money, more bang for your buck?
At that time, yes, ma'am.
Yeah. Well, and I agree with what the district attorney had to say, that it was, and the son, that it was totally premeditated. It was planned. I didn't see anything about it that you had any problems doing it whatsoever. And I don't know. I don't have anything else to say. A lot of it's been covered. I had it in my notes, and I have that you had no conscience, premeditated plan, point blank, and heinous. That's what I got. So I'll pass it along.
Any other questions? Any questions? I'll say this, Mr. Burgess, I've listened to everything that's been said. I do want to offer you some congratulations, I think, on the work that you've done, serving as a mentor to others, and the programs that you have completed. Did you do any, I didn't make a note, have you done any victim awareness programs?
Yes, ma'am. We did victims awareness in 200 hours.
Right, but no separate standalone victim awareness class.
No, ma'am.
All right. I do appreciate you mentoring the youth that you come in contact with. I think we're finished with our interview. I think we're prepared to vote. We'll ask Mrs. Stapleton to vote.
I'm gonna deny your request, and it's based upon the fact of the crime being premeditated, planned, heinous. That's my reason.
Mr.
Yes,
Prater?
ma'am.
I concur with deny victim opposition, DA opposition to be noted.
Mr. Freeman
Thank you, sir.
Law enforcement opposition.
and Mr. Tillis.
I concur.
Thank you, sir.
All right, Mr. Burgess, you received 4 votes to deny your application today, so your application is denied.
I appreciate y'all giving me a hearing. I
Yes, sir.
appreciate y'all giving me a hearing today. Thank y'all very much.
Well, good on him. He didn't get what he wanted, but he handled it really well at the end, so you have to appreciate that. Let's go back to Judge Middleton now.
She was unable to give a specimen, but she admitted to using marijuana and methamphetamine 2 days ago.
All right, thank you. All right, well, let's then address the sentence in the matter of People versus Natalie Nicole Welch. Ms. Welch was, as I stated, I think before she got here, charged with possession of methamphetamine, possession of cocaine, and possession of heroin or fentanyl. Heroin and fentanyl. 4 counts, was reduced to 1 count of use of a controlled substance. The matter was set for sentencing this morning. Daniel Frazine has been tasked with preparing the pre-sentence report. There was some trouble getting her in for the pre-sentence report. We did finally get it done. Mr. Frazine shares many of the same frustration I do in figuring out what to do here. Ms. Hines, what would you like me to know?
Your Honor, before we go forward, maybe, I would ask that the court consider canceling her bond and having a drug test before we go forward based on her admissions of use and her admissions of continued use while on bond to Mr. Frazine. I have concerns that she might not be coherent and with us enough to do a sentencing today. I'm certainly willing to have her come back tomorrow or when the court is available, but this is
fair enough.
A pretty significant reduction that was given.
When people come in with alcohol, I had a young man here recently, his blood alcohol level was 0.14, and we were about to do the sentence. We have a standard of how high is too high. And he was almost 1.5 times the legal limit. We can't proceed with a sentencing when the defendant's intoxicated. So we canceled his bond, spent the night in jail, and we proceeded with the sentence. It's harder of a standard to know with these sorts of tests. And we don't have a test. We have her admissions. And so I don't know whether she's coherent today or not. She seems to be. She was 20 minutes late, but I don't think that was her own fault. I think other people brought her here. And so she's still struggling with, frankly, I was more concerned about the fentanyl than I was the others, but I am very concerned about the meth as well. How old are you, Miss Welch?
20.
Yeah, so you're not even old enough to smoke marijuana yet. And so, Ms. Hines, what's your thought?
Natalie did say she probably would test positive, so she was honest with me. I don't know what to
Well,
say. I think she's here. Her mom brought her here. We have a pretty detailed pre-sentence investigation report, and she did indicate that she has started Celebrate Recovery. So that she needs some help. 20 years old. It's concerning that, like you said, Your Honor, she's used pretty strong illegal substances that really will ruin her life.
Yes,
She doesn't get a control of it.
The struggle is between just letting her go over the waterfall or trying to intervene. She is 20. And these weren't trace amounts, 1.67 of meth, some 1 point some of or 3.5 of some other stuff, then the cocaine, the fentanyl. I forgot they were in there. Addicts don't forget they got user amounts of controlled substance in their possession. She doesn't know whether her boyfriend uses drugs or not. So I don't think she was really upfront about everything. So I'll cancel the bond. I can't get in my scheduling profile right now. Laura, do you know what your schedule looks like this week?
Tomorrow I'm in Judge Patterson's courtroom at 9:30. And then I have a sentencing from 11:30 to 5 in Sturgis.
11:30, a sentencing.
A divorce mediation.
Oh, okay.
Sorry.
It just feels like.
It feels like it's. Especially this one. So I will be in mediation.
How are you for Wednesday?
I have an adjudicatory trial. Yeah, that's set for all day.
How are you for Thursday?
I have some people in my office, but I can work around that, Your Honor. We can move people if I need to, so.
Laura, what do I have for Thursday? It wouldn't let me log in first thing this morning in my ongoing litany of technical problems. I still can't get the Kramer box to work for the Javs recording and wouldn't let me log into the AS400. So
I'm assuming you have, does he have PCs tomorrow? PECs tomorrow?
I have PCs tomorrow.
I mean, I could be over here in the morning. I guess I'm next.
All right, why don't we set it for 10 o'clock tomorrow?
That's fine.
Does that work for you, Ms. Davis?
I'm doing PCC, so I'll be here. I'd like to have a screen still up there.
Well,
just to verify.
then there's some, we have to transport her to Three Rivers and somebody has to pay for it. We don't have a funding source to pay for her test.
I mean, I think if it's just a matter of giving a urine sample and she's not able to right now, maybe she could within the next hour.
Okay, so even get a urine sample.
Yeah.
All right.
I'm around all afternoon too. I mean, I have
we'll
some
set it
hearings
for
with
tomorrow
Judge
at 10.
Patterson, but other than that, I'm available this afternoon.
I guess I am interested, Ms. Davis, in knowing whether there's any opioids in there as well. So we're gonna wait until we get a test. All right, tomorrow at 10. Let's see what I got. No, I tried to call Chris because it won't let me in the AS400. Thursday would have worked also. All right, Miss, we'll take it up tomorrow at 10 a.m. here in this courtroom. We're gonna have her wait till she can give a sample. And we'll see really what it is we're dealing with.
Can they give her some water or something to drink?
Yeah. I'm concerned if there are opioids in there as well. We hadn't seen cocaine in a while and it started to make a resurgence. All right, Ms. Welch, you go back at the lockup. At some point, she's gonna need to get lunch, so I'm not sure. we'll work with Autumn and see what we can do.
So can maybe call out there and have them say referee. So you want her taken to the jail then, sir?
Hold on to her for now, then we'll see what Autumn wants to do.
Stand up, put your hands behind your back, please.
Should I leave her phone in here? Because we're not. That way I'll take theirs.
All right, well, that, excuse me, that young lady seems real off track already in her life. Hopefully stuff gets figured out there. Let's go back to Judge Webster to probably finish off our day.
Also $108 in court costs. If you do not want to serve the 30 days, make sure you understand that for 6 months from this date, you are on probation. You will not see a probation officer, but you're still on probation, which can be revoked and you can serve 30 days in jail. If you do not, again, want to serve that time, make sure that you follow your probation, which has primarily 2 conditions. First of all, do not violate any laws for the next 6 months. Second, pay the $608. How much time do you need to pay that, sir?
30 days.
30 days it will be. And you can contact the clerk of the district court for all your payment options online, in person, by mail, and so forth. But if you have that paid in 30 days and you don't violate any more laws for 6 months, your probation will terminate and this case will be closed. Any questions before I let you go, Mr. Hollingsworth?
I have none.
Mr. Bell, anything further?
No, Your Honor.
All right, then, Mr. Regier, anything further?
No, Your Honor.
Very well, Mr. Hollingsworth, you're excused. You may leave this call.
All right, thank you.
You're welcome. Mr. Bell, have you anyone else on the docket?
No, Your Honor.
All right, thank you. You're excused as well.
Thank you.
You're welcome, Mr. Lotz. I believe you're here on Gary Cooper. Will be on the record in 2023 TR 1542, State of Kansas versus Gary Dwayne Cooper. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Sean Lotz on behalf of Mr. Cooper on the Zoom, and Mr. Cooper is in another location. I had seen that he's already joined this meeting.
Yes, now I show that we were going to review his diversion.
Your
effort.
Honor, he was
Yes.
denied diversion, so Mr. Regier and I have reached a plea agreement in regards to this case.
And well, what is the agreement?
Your Honor, in exchange for a successful plea to the no proof of insurance, the state would recommend a $300 fine plus court costs, an underlying suspended sentence of 120 days, and 6 months of non-reporting probation.
That's your agreement, Mr. Regier?
One moment, Your Honor. Your Honor, based off my emails, I am unable to confirm if counsel for the defense and I discuss specific recommendations beyond non-reporting probation. However, as iterated on the record, the $300 fine, court costs, 120 days underlying, and 6 months non-reporting probation, the state has no objection to proceeding in that specific fashion.
And per agreement, count 1 speeding would be dismissed.
That would be the state's understanding of the plea agreement, Your Honor.
Very well.
That would, Your Honor.
Thank you, Mr. Cooper. If you don't, you disappeared. I think you may have hit the wrong button. There he is. Mr. Cooper, could you hit that little red microphone looking icon with the line through it? I can't hear you until you do that. There we go. Thank you.
Sorry, my connection was going in and out.
That's all right. Okay, so do you agree with everything the council, both council have said today?
Yes.
Then how do you plead to count 2, driving a motor vehicle in Butler County, Kansas on February 18th, 2023 without proof of liability insurance?
Guilty.
Is anyone making you enter this plea of guilty today by any threats or promises other than your plea agreement? Is anyone making you do this, sir?
No.
You understand that if I accept your plea, you will be found guilty. You will have given up your right to trial, and you will not be able to appeal your conviction.
Yes.
And that's what you want today?
Yes.
Where were you driving in Butler County on February 18th of 2023 that would have caused this action?
I honestly do not remember. I was headed to a basketball tournament in Missouri.
So if
I
the
was on the highway
officer,
somewhere.
if the officer said on his citation that you were on US 54 at milepost 239, would you agree that you're on Highway 54? I'm sorry?
Yeah, that sounds all right.
Okay. What town had you left and what town were you going towards? Okay, so you were leaving Wichita headed towards where? You said Missouri.
Oh,
All right.
honestly, I don't remember where I was. I was going to a basketball tournament.
All right, Mr. Regier, would you proffer the officer's ticket narrative as factual basis for jurisdiction?
The state would so proffer, Your Honor, if the court wishes me to address the specific location from the state's understanding, I am in a position to do so.
Go ahead, please.
Your Honor, the ticket in this matter does appear to refer to a stop occurring on US 54 at milepost 239. The state's understanding is that is well within Butler County boundaries, approximately halfway between Augusta and Leon city limits.
All right, that sounds more what I would have expected instead of Winfield. All right, I find we do have jurisdiction, and you are admitting that you did this, Mr. Cooper, is that right? One more
Yes.
time. All right, so I find that your plea is knowingly and voluntarily made as well. I find you guilty of driving without insurance. I will dismiss on motion of the state for plea agreement, the speeding charge in count one. For your agreement, I will fine you the minimum allowed by law of $300 and assess $108 in court costs for a total due of $408. You will also be given 120 days jail. You will not have to serve that jail if you are successful for 6 months on non-reporting probation. You don't have to see an officer, but you are on probation with the court for 6 months. During that 6 months, you have two conditions. Number one, don't violate any laws of any kind. And number two, get the 408 paid. How much time do you need for that, Mr. Cooper?
30 days.
30 be enough?
Yeah.
All right, then I will order that you have that paid within 30 days. Contact the clerk of the district court in Butler County to find out all the different payment methods that are available. But as long as you have that paid within 30 days and you do not violate any laws for 6 months, your probation will terminate, the case will close. If you don't comply with those two violations or conditions, your probation could be revoked. You could serve 120 days. Your license could be suspended, and or you could be turned over to a collection agent. Any questions, Mr. Cooper?
No.
Anything further with Mr. Regier?
Not from the state, Your Honor.
Mr. Lotz?
No, Your Honor.
Then we'll be in recess, and Mr. Lotz and Mr. Cooper are excused at this time.
Thank you, Your Honor.
Thank you, gentlemen. Any availability?
Okie dokie, we'll go ahead and leave it there for today. So if you were with us at the end of Friday's show, I tried to talk to you just like this, and nobody heard anything, and you all kept alerting me in the chat saying, hey, I can't hear you. So I went and looked, and I saw that the microphone source was turned off, so I turned it back on and started talking to you again. And once again, you told me that you couldn't hear me. So I just ended the stream. And later out, I found out I was disabled in yet a second place, and I know why. So before I went live that day, I had this particular scene set up, and it was up on the screen, and Ellie, my kitten co-host, was playing up next to me, and she'd walked across the keyboard. She hit a couple of hotkeys, but I hadn't been on this host-only scene the entire stream, so I didn't know until the end that she had broken it. So that's what happened on Friday when everybody was going, we can't hear you. Yeah, well, I thought I fixed it, but then I didn't. So I just said, I'm out. Because at some point, you just got to give up. The accused double mute. The accursed double mute. Yeah, that's exactly what happened. She not only disabled the microphone, she disabled the audio source overall. She hit 2 different hotkeys. Well, that is what happened, Ashley. You can pretend that's you thinking that I'm making up the story. I'm not. That's actually what happened. She's a terror. You guys know this. So anyways, I hope you all had fun today. I did. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Channel members, we forgot on this morning's pre-show to talk about the very, very bad, not good thing that Grandma TCF did yesterday while the power was out. So remind me tomorrow morning and we'll talk about that. And if you want to join us for the pre-show and you're not already a channel member, please do so. There's a link in the pinned chat. We would love to have you there. Give us a try for 1 month. I think you'll enjoy it and I think you'll have fun. So all of that having been said, go on about your day. Have a great Monday, and we'll see you again tomorrow. Take care. God bless.